Welcome to Case by Case. This is a podcast brought to you by Calum Chain and Luke Zadkovich of Zyla Floyd Zadkovich. Hello, Calum.
Hello, Luke.
How are you doing?
Very good. I've just about recovered from the excitement of Wagatha Christie.
I know. It's quite a come down after the highs of WAGs and leaks and PR and football. And we're back in some ship finance territory now.
We're back to the glamour of handy-sized bulk carriers.
Yeah. The vessels' names are called the Courage and the Amethyst, so make of that what you will. The case is called the case is between OCM Maritime, so Oak Tree Capital entities, and as the claimants, and Courage Shipping and Amethyst Ventures as the defendants, also the appellants. This is a decision from the English it's a Court of Appeal decision from the Commercial Court handed down recently on the 29th of July 2022. We have Lord Justice Males giving the leading judgment here, and the two other justices, Lord Justice Underhill and Lord Justice Newey, both agree, unanimous decision of the Court of Appeal. I think it raises some interesting points, this one, Calum, although in some ways perhaps more straightforward than some of the other cases we've dealt with recently.
Yeah, and I think so. We'll get into the background as we always do, but it seemed to me that this was a case that the charterers, in this case, the charterers and would-be buyers of the vessel, were very unhappy to have lost at first instance. I noticed that they changed counsel and they changed solicitors and then lost again in the Court of Appeal.
Didn't change the result, did it, ultimately?
Didn't change the result, ultimately. And I can see their frustration in the result is quite harsh. In terms of the context of the deal that they'd struck, the result is a harsh one, but it's, I guess, as with any harsh decision, there's a salient lesson, which is, be very careful in what you agree.
Well, isn't that the point? The point here with this case is, as I read it, or reading behind the decision, if you like, that the parties may have had a commercial deal, or may have thought they had a commercial deal. At least say the charterers thought they had a commercial deal, but that's not what the contract stated. The contract, ultimately, when I read it, the subject clause, we're going to get into it in a moment, it seems pretty straightforward. I don't think it's a difficult construction here at all. And the Court of Appeal had no difficulties going through Sir Andrew Smith, the judge at first instance's decision, and highly commending it in most places. And I think it's just that case of, you've got to be really careful about what actually ends up written in your contract.
Yeah, exactly. And so maybe it's helpful just to kind of talk about the background to this contract. So we can, as you said at the top, there are two vessels involved, two handy-sized bulk carriers, the Courage and the Amethyst. And each of these contracts is a bareboat charter party. And I think it's important to distinguish the use and function of bareboat charter parties, particularly the sort of bareboat charter parties that are an issue here, from a perhaps more quote-unquote routine or normal time charter party or voyage charter party that we might see an off-hire dispute under, or issues over condition. They are charter parties, but really they're financing documents. I think that's something that comes through in the way that this judgment is decided, but it's an important thing to appreciate at the outset. And what's happening here is that you essentially have a fund who are trying to they're entering into something which is akin to a loan arrangement, and the two parties, one of whom, the charterers, are going to have the use of the ship, and they're going to crew the ship, and they're going to do all the things, all the day-to-day operations with owning a ship. And then you have essentially the financiers, which is where the money's coming from, and their role is to basically assist in buying these these vessels. And the way they do that is they become the owners under these two bareboat charter parties. It looks as though the purchase price for the vessel was part paid by the charterers too. It looks like they put up about half.
I think considerably. I think it was half of the
So
purchase price was paid by the charterers for each of them, which is in large part why they feel so aggrieved by the ultimate decision.
And then they're paying off the remainder of, well, it looked as though they're basically paying off a certain amount of what is in effect of a loan to the owners. And the way the loan is structured is basically the owners buy the ship and the charterers pay them back for it over a long period of time. In this case, the charterers obviously pay it up front, pay quite a lot, and then it seemed as though, and you don't have the whole charter obviously, but it seemed as though there's basically a balloon payment at the end. So at the end of these bareboat charter parties, which were only about 2 years, if I remember correctly, the charters have the option basically to buy out the ships from the owners. So it's structured as a charter party, but in effect, what you have is a loan by which the charterers will eventually become the owners. And during the period of that loan, they're basically acting as the owners, save that they have this bareboat charter party arrangement.
Yeah. And what ultimately brought about the whole dispute was that Mr. Abdul Jalil Malal, who was the legal and beneficial owner of the shares in the chartering companies, was designated by the United States authorities as a specially designated global terrorist. Not the kind of designation you might want to receive, I dare say, Calum.
It's not an accolade, is it? Not one to put on your LinkedIn.
No, probably not. So that happened in June, that designation in June 2021. And the owners considered that, so that the listing of the ultimate beneficial owner as a SDGT, as an event of default under the bareboat charter parties for the two vessels. And so they gave notice.
Wording, just jumping in there, that wording, the event of default and the effects of these events of default is again akin to a loan. Under a loan agreement, you typically see these events of default that allow the financing party to wrap the whole thing up. And that's what we see here in this bareboat charter party.
Yeah, exactly. We're talking capital E, capital D. This is a defined term, event of default. And you've got to look to the contract to see what that means, as we'll get into in a minute. But so then the owners went on to give notice 8 days later after the designation to terminate the charter parties, and said that they would repossess the vessels at the next ports of call. But the charterers disputed that and disputed their right, as in owners' right, to repossess. In the event, owners succeeded in taking possession of the Amethyst in September, start of September, in Sharjah in the United Arab Emirates. But as to the other vessel, the Courage, the charterers caused it to proceed into Syrian waters, and the vessel remains there, or at least as at the time of this decision, and out of owners' reach. So we then have this dispute that comes on to determine really whether the owners had an entitlement to take possession of the vessels. There was no dispute as to whether the designation itself resulted in an event of default, but it's more about what's the consequence of that event of default. What could owners do? Did they have to give a certain notice making a demand for payment under the charter parties, or could they just go ahead and repossess the vessels as they did?
Yeah, exactly. And the reason I say at the start of this that the charters were so furious that they lost this, or appear to have been so furious they lost this, is that they, as we discussed, they've put up half the cost of the ship. They've then entered into this bareboat charter arrangement where they've continued to make payments, basis every single day of hire, but in reality monthly payments, repaying some of the amount that the charterers, that the owners had kind of fronted by buying the ship. And then suddenly somebody's name gets put on this sanctions list, gets designated as a terrorist, and the owners, effectively the bank, then say, well, thank you very much for paying everything that you've paid. We're taking the ships now. Good night. God bless.
Yep. And then at first instance, we had Justice Smith, as I mentioned before, fined in favour of the owners and said that, and found that the owners were entitled to terminate the charter parties, and they did so lawfully and effectively by the notices on the 18th of June 2021. They were entitled to repossess the vessels, and they'd been entitled to do that in respect of both ships, and in respect of the Amethyst, they had, in fact, lawfully taken possession of that vessel at the start of September. And then there were a couple of other arguments that charterers had run, around seeking relief from forfeiture of the charter parties. And the judge found at first instance that the charterers precluded themselves from obtaining that type of relief from forfeiture because of their own misconduct in these proceedings and, in relation to these proceedings. And in any event, the judge found that it would not have been an appropriate case to grant that type of relief. And this decision, so that was the findings, totally in favour of owners. They could keep the money that had been paid to date, and they got the ships. And this decision, which was an appeal by the charterers to the Court of Appeal, Court of Appeal basically went through these reasons, added some other additional reasons as to why the appeal should be dismissed, was dismissed, and why the original decision was a good one.
Yeah, exactly. And also, they provided some comment on this idea about whether or not the not really any clause. It's an interesting argument. The penalty clause argument is what I'm referring to here, where the charterer said, the effect of this is that it's a penalty. And I found that part of the judgment quite interesting, because I don't think the judge actually had to raise that, because I think that point was dropped on appeal. But the judge did go into the question of whether or not the contract as a whole created a penalty regime in circumstances where charterers effectively lost all of their investment in the vessel because somebody was placed on the designated persons list or the terrorist list, which there's some interesting stuff to go into there, I think.
Yeah, okay. So the case boiled down to, as we mentioned before, what rights did the owners have in the event of a default? And this was largely a construction question. What did the various clauses here in the charter party mean? And I don't think we need to go through all of them, but there's the termination clause, there's the repossession clause, but really the most critical clause, I think, unless you wanted to get into those ones, but I think the most critical clause is Clause 46, which sets out what owners are entitled to do in the event of a default. And really, there's a list of things that they're entitled to do. They're entitled to, give a notice about the aggregate amount of the outstanding principal and the indemnity sum to be paid, which shall become immediately payable in the event of a termination situation. So that's one thing they can do. They can take any action at law under the relevant documents.
Yeah, and that's just going back to that first one. Again, this just draws this parallel between this document and a loan agreement. Basically, the first one is your classic acceleration provision under a loan, where the bank can effectively say you're in default, therefore this is the amount that you owe us under the entire loan. It's now payable. And so in this situation, the owners under the bareboat charterers, who are effectively the financing party, have that right if they want it.
Yeah, exactly. And then the second point, sub 2, is almost follow on from that point, and that is to take any action at law under the relevant documents to collect the full amount as mentioned in the previous sub-clause, the acceleration clause as you describe it. So there's kind of two sub-clauses there which set out what owners may do. And then the third one, which is what they did here, was unless the full amount has been paid in sub-clauses Roman 1 or 2, as we just talked about, unless it's been fully paid in accordance with those two, the owners are able to retake the vessel under sub 3. And then there are some other points here as well. But I think this is the real critical part of this construction issue, is to unpack that owners have the ability to accelerate and make a demand for payment of sums. They're entitled, as a follow-on from that, to take action to recover the full amount. And then it says here, and or unless they've been paid fully under Roman 1 and 2, they can then retake the vessel. And it makes it very clear in the opening to these various rights in this clause 46 that it says owners may at their option, in brackets, but with no obligation so to do, close brackets. And I just, when I read that, without even going through the rest of the decision here, it seemed pretty clear to me that the way it's been drafted here is that owners had a pretty clear option as to whether they make the demand for payment of monies and or they retake the vessel.
So again, just looking at this from the perspective as though it's a financing document, basically you have two options if you're the owner / financing party. One is acceleration and take all the money, in which case charterers then keep the ship. Two is you enforce your rights against the collateral, which here is the ship. Effectively, that owners have title to the ship, and they can just say, well, actually, charterers, no thanks. And charterers' problem with this basically was that they couldn't comprehend that the owners were entitled to take the ship, i.e. take the collateral, but not give credit for the amount of money that they'd already received towards that. That feels like that was the point that caused them such consternation in this arrangement. But it comes down to the terms of the contract, right? This is the way that the parties chose to structure the deal, and this is the bargain they struck. And the court is not going to say, well, actually, we're going to deprive the owners, the financing party, of a rights that they're entitled to, just because it now, seems like it's unfair on charterers. It's just not going to happen.
Yeah. I think that's right. I really struggle to see a different interpretation of these provisions. And had the parties wanted to set up, or they had agreed to set it up in a way as to give credit, that could have been drafted in relatively easily.
Yeah, exactly.
Relatively easily. It's not a difficult provision to make clear, and we have seen many financing documents that would do exactly that.
Yeah, exactly. Yeah. Or as charterers tried to argue, they effectively said, well, you have to first give us this notice, so we have the option to buy you out of the contract. And the judge looked at this in quite a good way, I think, in a way which is helpful for any time that there's a construction question, which is if you're putting forward a construction argument, as charterers were here, saying, this clause should be read in a way where owners are obliged to send us effectively the acceleration notice and give us the opportunity to buy out the contract. Well, if you read the whole clause in that light, then does the rest of it make sense? And the judge did that and basically said, well, no, it doesn't, because the clause quite clearly says that the owners can, at their option, but with no obligation to do any of these things, do each of the things which is listed. And what charterers were effectively saying would cut across that, because the owners would not have the option and in fact would have an obligation to do certain things under this clause. So when you're trying to have a slightly creative construction argument, it makes sense to kind of go back through and reread the entirety of the contract in light of your creative constructive argument to see whether the rest of the contract actually makes sense. In this case, it didn't.
Yeah. And look, the court here ultimately held that the wording in clause 46 itself made clear that the owner has an option, but not an obligation to serve a notice under 46A1, that being the acceleration clause. And the wording in sub 3, and this is a quote, unless the charterers have paid to the owners a full amount as mentioned in clause 46A1, meant no more than if the owner has served a notice and the charter has paid, the remedies in those paragraphs are not available to the owner, which I think it's a pretty plain reading of the provision. And then the court also importantly held that interpretation of clause 46 was harmonious with clause 29, which provides the unqualified right to possession in the event of termination, while the charterer's construction was not harmonious with that. And then there were some other reasons as well. The court went on to also, and I'm now at paragraph 26 here, Calum, went on to find that there were some additional reasons to find in favour of owners on these construction points.
Yeah. And so the first one is kind of is this penalty question. And this was raised by charterers saying, well, the effect of this regime is punitive because we could, in essence, have paid half of the vessel before as part of this the sale and purchase. We could then have spent 2 years paying every single hire payment, every single installment, and then suddenly we could lose the vessel, which is effectively near enough what happened. And they say, well, the effect of that is punitive because some of these events of default are relatively minor, so this should be struck through as a penalty clause. What I found interesting in this, and I went back to the commercial court decision to kind of read it in a bit more detail, is that effectively the whole concept of a penalty clause could not apply to this contract because there was no secondary obligation that could be struck through as a penalty. And just to put some colour on that, basically, if you go back to 2015 when there was the Cavendish Square Holding and McDessie case, which was kind of twinned with the Parking Eye decision that went all the way through to the Supreme Court, the court held that a penalty clause was something where you have a primary obligation in the contract, and upon the failure of one of the parties to comply with that primary obligation, there then arises a secondary obligation, and that secondary obligation is in those punitive kind of unconscionable terms. Then that secondary obligation can be struck through as a penalty. And they said here there's no secondary obligation that you can point to, so it's not a penalty clause. It's a regime where your failure allows the owner to do certain things. It grants the owner a certain right, but it doesn't give you a secondary obligation, i.e. a secondary obligation to make a payment, which is required for there to be a penalty clause. And I thought that was interesting. It seems a slightly odd distinction to draw. If the contractual regime itself is punitive, then why does it need to be framed as a primary and secondary obligation? I mean, I doubt very much we're going to get more law on this because it's a very recent or relatively recent Supreme Court decision. So probably a while before one goes back. But I find that distinction slightly, at least I find it slightly odd that a regime can be punitive, but it can avoid being struck through as a penalty clause because it's not structured in a way where there's a primary and secondary obligation.
Yeah. I must admit I did not go back and look at the Cavendish case for the purpose of today's recording, but I do remember it at the time because I must have had another penalty case or looking at it at a penalty issue at around that time when it came out. And I wasn't convinced, I say that with a lot of trepidation given it's a Supreme Court decision, about the structure of this test with the primary obligation, secondary obligation. It felt a bit strained, and that may be just, the limits of my intellect or something, but trying to fit a number of these clauses into that, that more mechanical framework, I found difficult to do when applying it in subsequent cases. So, with the Cavendish decision, I then thought, well, okay, what's the primary obligation? What's the secondary obligation? Is this penalty? That to me seemed difficult and much more difficult than, the other ways of looking at penalty versus liquidated damages clauses, where is it a genuine pre-estimate of the potential losses and that kind of test. And I'm going off recollection here, but that kind of assessment where you could say, well, look, the parties at the outset came to a view as to what the losses may be. It may be very generous. It may be, it may be bang on. But if it was a reasonable pre-estimate or expectation of what those losses were, and they agreed to it, then even if it seems harsh after the event, it's not a penalty. It's LD. And that, to me, I've always kind of found a much easier proposition to understand and to follow.
Yeah, and I think I need to go back and read it fully, but I think you're in quite good company on that, because I think the Supreme Court was fairly split on this question of whether it needed to be or whether the penalty clause, the law and penalty clauses only bites on a secondary obligation. I think that was a split part of the decision. This was like 120-page Supreme Court judgment, and I think pretty much everybody on the bench had a crack at writing informing part of the decision. So it's slightly hard to piece together who went where, but I think that on this point the bench was split. I can see where they're going with it. If you look at the way that most LD provisions and / penalty clauses work, then often it is that structure of you've done some breach and therefore you have to pay this amount of money, and then you have the primary obligation, which is not to do the bad thing. They do the bad thing, and then the secondary obligation kicks in, which is you then have to pay us this amount of money. And if you can show that secondary obligation is unconscionable, then it gets struck through. I think that I can see how that's a neat analysis. I guess what I struggle with is if it's not that situation, but the result of the contractual regime still creates this unconscionable position where one party suffers a kind of extraordinary loss because of a breach somewhere, then just because that's structured as being a right that one party has rather than a secondary obligation, it would fall outside of the penalty clause regime. It seems slightly odd, and it's not something. This is the first time I think I've seen a case where that question has been kind of flagged so clearly. So it's an interesting one.
Yeah, I struggle a little bit with the concept of that in this case the owners have a right to repossess the vessel, but there's not some corollary. I'm not even saying that right. Some accompanying obligation on charterers to give back the vessel. Like I suppose it's in the structure of the clause and the way it's set up that it is an option and not an obligation for owners here. But if owners decide to take or exercise their right to repossess the vessel, there's not some secondary obligation on the charterers to give it back, and arguably in this case, the charterers clearly breached that obligation because they went on to put the vessel outside of owner's reach. It's why I kind of struggle a little bit with the primary and secondary obligation concept.
Which I guess
unless
kind of
I'm
segues us
missing
on.
something.
No, I think that's right. And there was the same thing. And this is now going a little bit off piste into a case I've not read for a while, which is the Cavendish case itself. And the bench from memory struggled with the same issue there, because effectively there was a relatively small breach, probably by Macdessi himself, that then meant that he lost the ability to buy something very cheaply. I think that's basically the facts. And he said, well, I shouldn't have lost my right. I shouldn't have lost my right to buy this thing very cheaply because of that small breach that I did, because me losing that right is a penalty. And the court ultimately held no, because there's no penalty obligation. So you can't say it's a penalty if there's nothing you can point to in the contract and say that is the penalty, that me being obliged to do this thing is a penalty. What you have instead is that you've lost the right somewhere, but that's not a secondary obligation.
Yeah, and look, in this case, I think, Calum, that, where I actually have a lot of sympathy for the owners is that we're dealing with a situation where the charterer's UBO was listed as, a global terrorist by the US on their designation list. And what are the owners supposed to do? They're supposed to try and, continue to be in contractual relations with these companies. There's going to be some artificial separation between Mr. Mallard and the companies and the chartering companies, and that the owners have to remain in, if they want to go down that route, that they have to remain in some type of contractual situation with them. And that's where this gets explored most in the decision, where the court upholds the first instance decisions on the relief against forfeiture, and to say that the charterers were not entitled to have that type of relief in this case.
And to an extent, I mean, I totally agree with what you're saying there. That practically speaking, how on earth do the owners stay in this arrangement, or even try and give credit to charterers
Exactly.
for what they've paid so far?
Exactly.
Because their hands are tied on this.
How did they
But
get paid? How did they get
exactly,
paid?
yeah, exactly.
You know,
They're stuck, right? And so all they can
exactly.
do, and it makes a lot of sense for the parties in that context to have agreed this mechanism. And you may say, well, actually looking at it through a different light, if something else happened that was not as serious, then it would create a regime that's punitive. But the court's not being asked to determine that hypothetical situation. They're trying to determine this situation, and they're saying, well, actually, it makes perfect sense that the owners may want to just wash their hands of the whole thing, take the vessel, and move on. And it does.
Yeah. Exactly.
I think
exactly. And then the other interesting point about this was that the court dealt with whether the charter's misconduct in relation to the proceedings precluded them from seeking that type of relief.
Yeah, which I think is the old law school unclean hands issue.
Yeah,
It's an equitable relief.
yeah, exactly. And there's a catalogue, or a lengthy catalogue of defaults on the part of the charters.
They didn't cover themselves in glory here, to be honest. And actually, even at the date of this judgment, it appears that one of the vessels still hasn't been redelivered back to the owners.
No, exactly.
It's a query how they're ever going to get their hands on it.
The charters, didn't cover themselves with glory in how they dealt with all of this, and I don't think that was ultimately determinative of the issue. This turned on the construction point under Clause 46, but when it comes to the equitable considerations, and you can imagine in a different factual situation that the charters may have got more mileage in some of these equitable arguments.
Yeah, I think that's right. But as it stood, if you're ignoring the orders of the courts, if you're giving evidence which is full of holes and likely untrue, and if you have this big list of reasons why the court can say, you're not coming to the courts of equity, you're not coming to the court's equitable jurisdiction with clean hands, then you're not going to get equitable relief. And the Court of Appeal seemed very happy to uphold the first instance judge on that.
Yeah, and also I think the only other point I want to really make on this equitable, relief against forfeiture point, and this really goes to a lot of equitable arguments, is that you have the procedure, you have unclean hands, that type of doctrine. How do you approach the court and on what basis, and how have you acted in the whole equitable scenario? But also you then have the substance or the merits considerations. And here the judge found on the unclean hands, and we're calling it unclean hands, it's not actually what it was described as here, but in weighing the equities on the procedure, said that their misconduct precluded the charters from getting relief from forfeiture. But then the judge didn't have to, but did go on to deal with the merits. And the court also looked at those as well. And that was like some of the considerations in there were that the owners were going to get a massive windfall, as the charters alleged, as a result of this outcome, and that the vessels had increased significantly in value from what they were originally. And this was, as I say, going to end up meaning that the owners did very well out of the scenario. And the court, I think, was... And maybe it was largely because the matter had already been decided by this point in time, so it didn't really matter. But I thought the evidence cited in the judgment around valuation was a bit light, to be frank. I don't know what your thought was of that, but they said that, there seemed to be problems with the main engine, that the vessel was not allowed an inspection by the owners, that there were a number of kind of procedural misconduct type issues in and around getting to the right valuation, which allow the court to just say, well, you know what, the market desktop valuations could be criticised here, and we're not convinced that the owners would make such a significant windfall as was being alleged. As well as the point about one vessel's no longer in a reachable state. It's off in Syria, and the owners are struggling to get possession of her.
Yeah, exactly. And the estimates themselves for the vessel's valuation were pretty broad. It wasn't as though someone had come to a firm landing on the precise value of these vessels. There were desktop analyses that hadn't or couldn't take into account other issues that had happened with the vessel, and one of the vessels had certain maintenance problems that would have to be factored in. It wasn't a point that seemed to be that persuasively developed, and ultimately it wasn't something that needed to be because of the way that the decision went. But I agree with you on that.
Well, yeah, interesting. So look, ultimately the owners succeeded, the charterers failed. Moral of the story is don't get listed as a specially designated global terrorist. Otherwise you may lose your ships, or at least put your trade towards them.
Yeah, exactly. A salient lesson for us all.
So I don't think we'll see this case again going higher, but famous last words and all that.
I suspect not. I think there have been a couple that we've seen in the Court of Appeal that are probably more likely destined to go all the way to the top. I suspect this is the last we see this one, but you never know. Maybe they'll take the opportunity to ask some questions around the primary and secondary obligation analysis that we discussed.
Maybe. Thank you very much for listening in, everyone. We hope you've enjoyed the episode today. Thanks for being with us. And if you've liked it, please like, subscribe to our podcast. You can find us on Spotify, Apple Podcasts, and feel free to share this with anyone in your team or people that you think might be interested. We'll be coming to you with another podcast next Thursday. So until then, take care. See you, Calum.
Cheers, everybody. Cheers, Luke. Bye.